we're going to get started. Good morning. Sorry for the delay. We are so excited to have everybody here. My name is Amy McDonald. I'm a student here at the law school and the president of Social Justice Student Initiative here, and one of the organizers of this event. Thank you, Professor George. I can't emphasize how thrilled we are to have you here. I honestly saw 3 people in the elevator coming up, and I was so excited that there were 3 people here. So thank you so much. I don't know why we have great attendance every year, but thank you so much. And I want to start out by giving a big thanks to my board and my 2 co-organizers, Kimberly and Cara. Will you stand up? These ladies have worked tirelessly to make today happen, and many others on the board are responsible for all of the inner workings of this event. And we are just so excited that today has come. And thank you also to the S.J. Quinney College of Law, the amazing event staff, and the Tanner Center for Humanities for being our generous sponsors this year. And thank you all, especially for being here, if I haven't already said that. And we're especially grateful that Kathleen Kim is here. I am so excited for you all to hear her. She is so knowledgeable and also very dynamic, and we are just thrilled to have you here, Kathleen, so thank you. This event was founded by Nubia Pena, a student here at SJQ about 5 years ago, and it was a small grassroots event run entirely by students. And each year it's grown in size, and as the board for this student organization, we inherit the task of putting on this symposium. For the past year, we've been working to make it happen, and the symposium was not our original idea. We didn't come up with it. We don't have expertise in the topic of human trafficking. Many of us joined SJSI for reasons unrelated to trafficking or only tangentially related, and we are definitely not the most qualified or knowledgeable people on this topic. But we are happy to volunteer and are tasked with running the 5th annual Human Trafficking Symposium. So why, if we don't know much about this topic, are we tasked with and remain willing to put this event on? And I was thinking about this last night, and I have a hunch that it is similar to the reasons that you all are here today. While some of you are experts in the field of trafficking, we have some wonderful panelists and speakers lined up for the rest of today. For most of you, trafficking is something that likely only slightly touches your everyday work, if ever. Perhaps this was just the most interesting CLE you could find. Or maybe you work with vulnerable populations and trafficking is not your bread and butter, but you'd like to learn more about it. At the risk of sounding cliche, I think that the reason you are here is a very good one. Not only do you have hope that the work you do will make a real impact on the quality of justice that others receive, but you also want to arm yourself with more knowledge to do so. You could have gone to another symposium or CLE, and you could have chosen to spend the day at your desk or, maybe skiing or doing something fun, but you are here, and I think that you should feel very proud of that. The work of social justice is one that we are tasked with and remain willing to do, even when we are not the world's foremost experts, because it is the right thing to do, and it's even more right to learn about it and to become experts on this topic. And we are all students in one way or another, and we come here to learn and develop more knowledge to help those who will come across our paths. Today, that knowledge will be about our theme, migration and trafficking, the vulnerability of movement. A migrant is any person who is moving or has moved across an international border or within a state away from his or her habitual place of residence, regardless of their legal status, regardless of whether the movement is voluntary or involuntary, regardless what the cause of that movement is, or what the length of their stay is. These individuals are at significant risk for trafficking. Many are lured into migration by promise of employment, safety, or legitimate status in the country of immigration. Others are victims of crime, such as kidnapping or sex crimes. The result is often enslavement, violence, torture, and even threats of death. The intersection of these occurrences within those who are in movement for one reason or another is why we are here today. In Isabel Wilkerson's sweeping history of the American Great Migration, The Warmth of Other Suns, she described African American migrants leaving the South in this way. They did what human beings looking for freedom throughout history have often done. They left. Not all migrants leave their place of origin because they're looking for freedom, but leaving is a human theme that will always be with us, and those who leave are more vulnerable to the atrocities of trafficking. Between the work we do on a daily basis and the national dialogue regarding immigration and the movement of people worldwide, today you can feel good about sitting in the seat where you are. You will be enlightened by those who do this work on the ground and others who study it at a macro level. And I cannot offer my own expertise as I do not have any, but I can promise that you will be personally and intellectually rewarded for being here today. So thank you so much for being here. And with that, I'll turn the time over to Kim, who will introduce our speaker, Dr. Kathleen Kim.
You can see why Amy is our fearless leader at SJSI. Thanks, Amy. All right, before I read Kathleen's beautiful bio and all the work that she's done, we want to invite you to participate in the Q&A, which will follow Kathleen's presentation. And to do so, you have two options. You can either download the app for Slido here and submit questions that way. Additionally, we will have mics that you can just raise your hand old school style, and then you can also ask a question in that way too. So once we get to that point, as you're thinking, just submit your questions. We'd love to hear what those are, and Kathleen is offered to answer them for you. Professor Kathleen Kim is an expert on immigrants' rights and human trafficking. Her scholarship appears in the UCLA Law Review, Iowa Law Review, University of Chicago Legal Forum, among others, and she is co-author of the leading casebook on human trafficking. Professor Kim is also the founding faculty supervisor of the Loyola Immigrant Justice Clinic, the primary provider of pro bono immigration services to indigent non-citizens on the east side of Los Angeles. Previous to joining Loyola, Kim launched the first legal services project in the nation dedicated to representing the civil rights of trafficked workers as a Skadden Fellow at the Lawyers Committee for Civil Rights. She was also the inaugural Immigrants' Rights Teaching Fellow at Stanford Law School. Kim served as a gubernatorial appointee, which I hear is by Schwarzenegger, she's told me interestingly enough, appointee to the first California Department of Justice Alliance to combat trafficking and slavery. From 2013 to 2016, Kim was a Los Angeles Police Commissioner, during which time she advanced sanctuary reforms in the city of Los Angeles. In 2014, Los Angeles Magazine named her one of Los Angeles' 10 most inspiring women. In 2016, the National Jurist selected her as one of 20 law professor leaders in diversity. She serves on the advisory board of Coalition to Abolish Slavery and Trafficking and is a board member of Asian Americans Advancing Justice Los Angeles. Professor Kim received her JD from Stanford Law School, where she was a judge. Oh gosh, I didn't ask you how to say this name. Takasugi, thank you, where she was a Judge Takasugi Public Interest Fellow and an editor for the Stanford Law Review. In addition to this, I will just add my own words that last night our board got to have dinner and discuss with Kathleen, and just as amazing and accomplished as she is, on paper I can tell you that in person she is kind and she is genuine and she cares about this work and she's invested in students, and which is why we are so grateful to have her here today. So if you all help me in welcoming Kathleen Kim.
Wow, it's such an honor to be here, and the experience that I've had with the academic community so far has been really incredible, and I'm grateful for that. I feel at home here, and since I teach at Loyola, and I'm biased for Loyola, I told the students and the professor that was present last night that, well, I think you guys would all fit in really well at Loyola. But I know that you serve an important purpose being here, and the social justice commitment of these students, and also the sophistication and their humility has been very inspiring for me. And I think that is a tough act to follow from from both Amy and Kara, but Amy and Kim. But I'm going to do my best. And my plan is today to talk about human trafficking. As Kim described in my biography, my entire career has been dedicated to anti-trafficking efforts, and it began in law school. The interest was first sparked before law school when I taught English to migrant farm workers in the eastern hills, or the eastern agricultural fields of Michigan. I grew up in Detroit, Michigan, went to University of Michigan. As a naive, young 20-something-year-old, and had a desire to understand more of what the immigrant story is from different immigrant perspectives, because I grew up with one that was profoundly significant in my life, which was my parents' immigrant story. And they grew up during the Korean War and had never really had a country of their own, because previous to the Korean War, Korea was subject to Japanese occupation. And then after the Korean War, South Korea was independent, but it did not have its own governmental structure. And that's when the US government made a very long-term commitment to building a government in South Korea. But at the time that my parents grew up, what they perceived was really a military governance that did not represent their own national identity. So they very much had a desire to move to the United States, and to them, like many immigrants, the United States was a symbol of freedom, where they could truly pursue life, liberty, and happiness. And in 1966, they had the good fortune to benefit from the repeal of the last of the Asian Exclusion Acts, which occurred in 1965. That's when in the United States, our immigration laws were reformed. It was during the Civil Rights Movement, and Congress recognized that our previous immigration system operated on quotas, which determined the number of entrants from each country, and which was clearly a race-based determination. So that system was replaced in 1965 with an objective system, which permitted immigrants from every country to immigrate within the same cap, of which has remained around 25,000 individuals. That's had disparate consequences, however, because the countries that the U.S. has had a long-term historical relationship with, like the Philippines, for example, there were many Filipinos that had an interest in immigrating to the United States, so that 25,000 cap is easily fulfilled every year, and so there's a tremendous backlog for individuals from a country like the Philippines to come to the country, even though they're legally eligible to. And that applies to other countries with vast populations like India and China. And then Mexico, which the U.S. also has a historical relationship with, that backlog has resulted in sometimes 24 years of wait time for a family member to receive a visa to legally come into the country, which, as I'm sure many of you understand, is one of the characteristics of our broken immigration system. What I'm going to focus my remarks on today, though, is a different part of our broken immigration system, which is human trafficking. But I want to put it into a larger framework of immigration and its relationship to the Constitution. And the reason why this is important, and immigration's relationship to the Constitution is always important for any doctrinal understanding of what immigration law is. But I think it's especially important now, 2 years into our current administration, when it's not just immigration that is a topic of scrutiny, but it's actually the condition of our country in general, and the happiness of all of our residents, of our country's residents, citizen or not. Especially for law students, legal academics, and lawyers, what has been commented on frequently by the media is what we've referred to as a constitutional crisis. And what that means is an absence of the kind of separation of powers that we once understood as being a foundational principle of our democracy, of a liberal democracy, and also of the Constitution. And that balance of powers also has given those who chose the legal profession, and I was talking with my dinner companions last night, that we were all legal reformers. We all made a choice to work within the system, to advance change towards social justice by working within the system. And now, when I speak among my colleagues, with my colleagues and my students, we realize that the system has less tools available for us to correct the kinds of wrongs that we observe, and the Constitution itself has given us less hope for a positive future that reflects the democratic principles that we believe in. When I first came to law school, and when I first decided to pursue immigrants' rights work, and within that spectrum, within that population, are trafficking victims. And trafficking victims are those that are defrauded, coerced, or forced into work and are unable to leave that work situation. The mechanisms by which individuals are kept into compliance with substandard working conditions, the law recognizes a broad range of means that an employer or a trafficker might use to keep them there. And there's a long history of court disputes over what kinds of means could establish a forced labor violation. And I'm going to go into the doctrinal history of that. But ultimately, what we have now under the Trafficking Victims Protection Act, which was passed in 2000, was a significant leap in the law's understanding of what could force people to work. And that included psychological means of coercion. It included threats of deportation, threats to retaliate against one's family members, but it also included subtle intimidation, so references or euphemisms for serious harm that might occur to the worker if the worker did not comply with the work situation, such as indirect threats to reputationally harm the worker or financially harm the worker, like withholding their pay. That has all become within the gambit of our understanding of what human trafficking is today. So I came to that issue as a young law student because I believed in democracy. And that population, to me, exemplified the antithesis of democracy. Because, as many of you know, our Constitution does not make distinctions between citizens and non-citizens. Our Bill of Rights are considered fundamental rights that anyone within our country's territory, for the most part, are entitled to receive. So, if a non-citizen is held in involuntary servitude, the 13th Amendment prohibits that. So the traffic population is an aberration of democracy. And I had a desire to correct that, as I'm sure many of you do now, and you do as well. But now, we meaning those of us concerned about a population that has been left out of democracy, we are burdened with with having to protect our democracy in general. And so that's the framing that I'd like to use for my remarks for this forum of our discussion, because I'd say that trafficking victims are a easily identifiable population, not in the practical sense, but in the sense of democracy. You know, our democracy should protect individuals that are victims of 13th Amendment violations. But what else? And the what else is, over the last 2 years, because of the confusion or the blurry lines between separation of powers, or perhaps the overtaking of executive power over the checks that are built into the Constitution, meaning our other political branch, Congress, as well as the judiciary, have had little ability to intervene in executive power, and that has a lot to do with just how our immigration system is set up. For those of you who don't know, our immigration system is based on the plenary power, which gives the political branches, meaning the executive and the Congress, complete authority over immigration, regulation, policy, and practice. So the president is indeed empowered to enact policy under his administration, as previous presidents have done, to advance policy measures that they believe in the immigration context. So under Obama, not only did we see record highs of deportation at the border, but also remedies for those residing in the United States, otherwise law-abiding, and we have an enormous population of DACA recipients who have gone on to law school, and some even practicing law, and have made huge leaps and bounds, and would not have been able to do so without that executive action that permitted DACA. So Trump's executive actions reveal opposite ideals, opposite norms, and there's a litany of executive orders that he's passed that harken back to pre-Civil War times. And again, if we take the framing of this conversation to the question in a broader sense of, you know, what is our democracy, then these historical connections matter even more. So when Trump took office, he immediately initiated the travel ban, which was outrightly rejected by the courts because it was explicitly racist. The third round, when avoided those kinds of race implications and was permitted to go into effect. Then, as Trump campaigned, he rescinded DACA, which, you know, if you really think about it, is an example of probably one of the most inhumane things that anyone could do, because our community members, my students, your students, who had already been residing in the United States for a long time and had achieved a lot, now in law school, desiring to join the community of social justice lawyers, at any moment. Fortunately, it's being litigated, so that buys us some time. But at any moment, through executive power, as we've seen, Trump could make another change, making life more difficult for DACA recipients. Border patrol. So, and Trump has been very aggressive about desiring increase in border enforcement. The reality is, though, even though Congress was allocated to Trump something like $6.7 billion for increased border security at the beginning of his term, and the Trump administration, or DHS, was mandated to hire 2,700 new border agents. They hired a recruitment agency to find individuals to take these positions. Only 33 have. So there's a disconnect between who we are as a country and the population in our country and what our current government's policies are towards immigrants. I want to believe it's because many of us perceive immigrants as part of our integrated community. That's because they go to church with us, because they work with us, and because they're our friends. And that has more staying power than their non-citizen status and the inability for, as a result, for them to vote or receive public benefits and always be at the risk of deportation. And now, so getting back to trafficking, the Trafficking Act was passed in 2000, and it came about as a result of a long history of the meaning of involuntary servitude under the 13th Amendment. The 13th Amendment was enacted to abolish chattel slavery in 1865. Chattel slavery is defined as state-sanctioned slavery, where private owners could own slaves. And as a result of that relationship, slaves were subjected to egregious violence and also criminal penalty if they fled from their slave owner. Back then, there were fugitive slave gangs who were permitted. They operated like bounty hunters. So if they heard of fugitive slaves, they were permitted to go find that slave, return that slave to the owner, and they'd receive a fee. The fugitive slave gang would receive a fee. If the slave refused to return to the slave owner, then they'd put in prison, where they'd be subjected to hard labor, which was a valid form of punishment. And under the 13th Amendment, hard labor is still a valid form of governmental punishment. That was chattel slavery. The enactment of the 13th Amendment, a lot of people, we forget how politically motivated the discussion around the 13th Amendment was. Abraham Lincoln has been revered as one of our nation's greatest presidents, and I think it's because he was a great negotiator. He was up for re-election, and he needed to balance the interests of laissez-faire Republicans and liberal Democrats. So the laissez-faire Republicans were adamantly against slavery. That's because this was during a time that was the inception of our Industrial Revolution. And if a relationship of ownership existed between a slave owner and a worker, that was antithetical to laissez-faire capitalist economics. Republican legislators believed in free labor in the sense that every individual is a free agent, and freedom to contract, even if one is selling one's labor to another, was fundamental to the advancement of capitalism and economic prosperity in our country. Those Republicans aligned with moral abolitionists, so abolitionists who deemed slavery as inhumane and wrong, morally wrong. That coalition put a lot of pressure on Lincoln, and again, up for re-election, he advanced the Emancipation Proclamation. 13th Amendment was enacted to abolish slavery, but at the time, that historical period, it stood for freedom of contract, which is a very different understanding of how we understand our contemporary knowledge of definition of human trafficking, and also the definitions of subsequent statutes that were enacted pursuant to the 13th Amendment congressional, Section 2 congressional power. The statutes that were enacted subsequent to the 13th Amendment responded to new manifestations of slavery and what I call new forms of unfree labor, because chattel slavery was distinct. It was the forced migration of African slaves, and our country was built on the backs of those individuals. And a lot of the structural reasons for our wealth inequality in the country has to do with that significant time in our country's history. Really laid the foundation for what became a democracy. And so chattel slavery occupies an extraordinary and special place in our history, which should not be diminished by the subsequent forms of unfree labor that followed. That's why I'm clear on that distinction. Nonetheless, those subsequent forms of unfree labor were certainly egregious, and there was congressional action and court action to overcome those forms of unfree labor and prohibit them. So after chattel slavery was abolished, freed slaves, recently freed slaves, but also migrant labor started to occupy the labor positions that slaves and plantations once held. And there were new industries because it was the Industrial Revolution. Chinese migrant workers came to build the railroads. Mexican workers came to work in the agricultural fields. And freed slaves continued perhaps to work on plantations, but now they're freed slaves and entered into contracts with their employers, which were essentially peonage contracts. So the employer would say, well, I'll cover your room and board and you work for me for free. But so long as the worker, now a free agent because slavery had been abolished, agreed to the contract signed or agreed to the terms of that contract, that contract was deemed valid. That freedom of contract theory prevailed for a long time. And there were many instances of breaches of those contracts because workers, Chinese railroad workers, Mexican agricultural workers, and free black slaves, they entered in these contracts, realized, well, this is just like slavery, so I'm going to leave. And once they left, that was deemed to be a breach of contract punishable by criminal penalty. So fugitive slave gangs transformed into what today is the police. The police doesn't do that. They're not empowered to throw people in jail for breach of contract, but these are the historical origins of police. So individuals who breach contract simply because the working conditions were intolerable, they were subject to imprisonment when they breached the contract. Either they needed to honor the contract, go back to that employer, or were subjected to criminal penalty. So the Supreme Court in Bailey versus Alabama, it's an early 1911s case, determined that there's no freedom in this contract. What this does is extract labor from an individual without reciprocating any value. This looks like slavery. It's at that point that the 13th Amendment actually started to gain a different definition, moved away from freedom of contract to a definition of what I call freedom from coercion. So the 13th Amendment didn't start out as a free labor concept. It started out as a freedom of contract concept. And it was because these persistent forms of exploitation of our market, of our capitalist market, kept on occurring, is that an idea of free labor evolved. and this is also at the same time that labor unions started to evolve. FDR became president. The New Deal occurred. Now we had federal workplace standards. First time. Basic workplace minimum wage and hour standards. And there was a lot of objection, a lot of litigation around that from states who believed in freedom of contract. In order, and they had good arguments, in order for our country to sustain the kind of economic prosperity it had, it was important for workers to work around the clock and for employers to extract as much labor as possible. And in the end, it would benefit our economy. But no, this was a point where the government intervened, the government in the form of the Supreme Court and then Congress. Supreme Court said that this is a form of slavery because it does not permit the worker to quit. Any workplace that does not permit a worker to quit is an unfree workplace. Labor rights means that the worker can assert basic fundamental rights and be able to complain to their working conditions without threat of physical or criminal legal penalty. Congress then acted with the Anti-Peonage Act after a series of cases. That congressional action didn't happen until the 1940s, however, so like 80 years of peonage had occurred with the Supreme Court declaring that peonage was unconstitutional. Okay, so then the next statute that Congress enacted pursuant to the 13th Amendment was a statute prohibiting or criminally involuntary servitude. The statute merely stated that involuntary servitude was prohibited and would be subject to imprisonment, punishment for the crime, and indicated that, well, the 13th Amendment actually indicates this as well, that private parties can violate the 13th Amendment and involuntary servitude and peonage. 13th Amendment, as you know, other bills of rights, as you know, require governmental action. 13th Amendment does not. So involuntary servitude statute was passed, but there was no definition to what it meant. And at the time, this is mid-20th century, Department of Justice, first time that a civil rights division had been enacted in the Department of Justice. This is an important period in the Department of Justice. This is when Department of Justice lawyers were very concerned about what civil rights meant and were very concerned about advancing civil rights. And this went through the 60s, and we had a Congress that responded with the Civil Rights Act and the Immigration Nationality Act provision that I mentioned earlier, which eliminated race-based quotas from countries that were where immigrants were coming from. Okay, so the Department of Justice Civil Rights Division, they wanted to prosecute cases that appeared to be unfree labor cases. But they didn't look like chattel slavery, because chattel slavery no longer exists. There was no longer government-sanctioned ownership of slaves. And they didn't look like peonage, because there was not necessarily a contract or a payment or a debt that needed to be repaid to the employer. These cases, a primary example of which is U.S. v. Ingalls. This 1948 case involved a black domestic worker who had been working for the same family for over 20 years, and since she was 17 years old. She did not know life outside of working for this family. She toiled around the clock. When she started to gain wisdom that she shouldn't be treated as she was, she started to complain, and her employers responded with threats to, she had an affair, although that's a little bit unclear. There's a blurry line. Perhaps she had been raped by one of her employers, and had been impregnated and had to have an abortion. And so her employers threatened her that they would make that knowledge public, which would be hugely stigmatizing to her. So she stayed as a domestic worker, a forced domestic worker. The Department of Justice brought a prosecution on behalf of Dora Jones, the worker, against the Ingalls family. And they brought it under the involuntary servitude statute, and they claimed that she had been treated akin to a slave. There's little evidence of physical violence, and there's no evidence of actual legal penalty, because the reality at the time was if she had left, she would not have been thrown into jail because peonage had been outlawed. What she was subject to, the Department of Justice argued, was involuntary servitude, which involves subtle means of coercion that don't include the physical restraint that was sanctioned by the government in chattel slavery, and don't include the criminal penalty that was permitted before peonage was prohibited. At the time, the Department of Justice won that case. Unfortunately, after that case, there were other cases that the Department of Justice continued to bring on behalf of victims that look very similar to what trafficking victims look like today, and the demographics of trafficking victims today. So another famous case, U.S. v. Shackney, got up to the Second Circuit. This involved a migrant seasonal worker family from Mexico, the Oros family. And they worked on the Shackney farm, and they had isolated living conditions. They had restriction of movement. They were forced to work around the clock, paid very menial pay, and were subjected to threats of deportation if they complained to the Oros family about the working conditions. That case, under today's standards, is explicitly trafficking. Unfortunately, at the point that it got up to the Second Circuit disagreed. And the reason why is because the Second Circuit used as examples for what forced labor was, in looking at its historical origins, concentrated on chattel slavery and peonage. This wasn't chattel slavery, and this was not a peonage contract. There wasn't an enormous debt that this Oros family had to repay, and if they did not, they would not have been subject to criminal penalty or imprisonment. Threats of deportation is not a criminal, deportation is not a criminal consequence. Today, it still isn't a criminal consequence. Immigration is a civil process. That's why non-citizens, we are shocked by the lack of due process that they receive. Criminal defendants constitutionally receive due process protections such as appointed counsel, jury by their peers, avoidance of cruel and unusual punishment. Non-citizens don't enjoy that in the immigration context because it's a civil process, not a criminal process. So the Second Circuit decided this is not involuntary servitude. Involuntary servitude cannot include these threats because these threats don't result in any kind of physical restraint or any kind of legitimate criminal penalty. The Ninth Circuit, some years later, came out with a conflicting opinion, and this was U.S. v. Musri. It involved a group of Indonesian domestic workers who've been trafficked from Indonesia to work for the Musri family in California. The workers were kept under tight supervision. They worked under around the clock, menial pay, received threats of deportation, received threats of harm to their family members if they were to complain. This time, the Department of Justice was successful. The Ninth Circuit agreed that even though there was not evidence of physical abuse or any kind of legal restraint, the Ninth Circuit agreed that in modern times, the perpetrators of these crimes have advanced methods of keeping under control victims. One of the key factors in this case was the confiscation of the passports of the victims. And they didn't know that they could leave without their passports. To them, they needed to have their identifying documents in order to receive help, and at least help from law enforcement. Another digression, the very sad thing about today is that what we hoped previously were misunderstandings of law enforcement in the past. I mean, up until 2 years ago, I would often, when I was in the field, often counsel my clients, our government is not corrupt. We have really good law enforcement officials who are educated about these issues and also know how to collaborate with victims to bring perpetrators to justice. Unfortunately, because of explicit policies within the Department of Homeland Security, the priorities of our immigration enforcement officers have changed dramatically. There was a recent report, and there have been incidents of this in the past, what's called rogue ICE operations, where ICE investigators basically impersonate less threatening actors and, in a way, entrap unaware, otherwise law-abiding, but unlawfully present, which again is a civil violation, not a criminal violation, unlawfully present non-citizens. And there was a fraudulent school called University of Farmington near where I grew up that was basically an empty building that ICE operators were operating and had set up and advertised as a legitimate university, so that foreign student visa holders here in the country who basically didn't want to take classes anymore would enroll in the school so they can maintain their visas. But in the end, that institution was actually created to entrap those individuals and put them in removal proceedings. So victims who are continuously trafficked and remain trafficked right now, they are legitimately afraid of our law enforcement agents. So Musri came out the other way. They understood the credibility of victims who feared law enforcement, even if back then they had nothing to fear. The Supreme Court resolved the circuit court split in 1988, and it was a majority opinion written by Sandra Day O'Connor. The case involved 2 victims, U.S. citizens, farm workers, adult men who had intelligence quotients of something like 68 and 71 respectively. Highly vulnerable individuals, had the aptitude of small children, and very vulnerable to Kosminski and his control of them to work on his farm. So they live in horrible conditions, a dilapidated shack, no utilities, no tools to keep healthy and sanitary. The Department of Justice brought a case on their behalf. The workers, just like in the other cases, there was little evidence of any kind of physical abuse, and there were no credible threats of legal restraint. What they were subject to by Kosminski were threats that they would end up in a mental institution if they left the care of Kosminski, and they had the vulnerability of small children, and to them that threat was powerful enough to keep them enslaved. The Kosminski court, even while recognizing all of the nuances in what kept the workers in that situation, nonetheless sided with the second court in its definition of involuntary servitude, a narrow definition that involuntary servitude could only be established if the perpetrator demonstrated either direct or indirect through threats of physical harm or legal restraint if the workers failed to comply. That's the definition that the majority in U.S. v. Kosminski adopted. I interestingly, another aside, I gave a talk at the Sandra Day O'Connor School of Law in Arizona, the Keynote, in a situation very similar to this, but my remarks were much more focused on the Kosminski case because it was closer to the inception of the Trafficking Act, and she was sitting right here, and I respect her greatly, but part of my comments included criticism of that opinion, but I think she had fallen asleep by the time I got to that part. So I got by while maintaining integrity of my remarks, but also really happy that she seemed to be asleep. Okay, but no, she did give an opening in that majority opinion, and that opening was a call for congressional action because this statute was so ill-defined. Congress should enact another measure. So finally in 2000, again with the persistence of these Department of Justice lawyers that were still pursuing these cases of modern day forced labor, and they lobbied for congressional action. And there are other important stakeholders that were pushing for new legislation to provide a definition for what is human trafficking. The 2000 law defined human trafficking for the first time. It defined them the binary definition: labor trafficking, forced fraud or coercion into forced labor. That's a truncated general version. And sex trafficking, forced fraud or coercion into the commercial sex industry. But if the victim is under the age of 18, because under the law children cannot consent, especially that kind of activity, then children in the commercial sex industry, regardless of how they got there, are de facto victims. Now, today, we see vast numbers of domestic victims of sex trafficking. I served as a Los Angeles Police Commissioner. I can tell you from my experience there, the proportion of sex trafficking victims is largely due because of the definition of child sex trafficking victims, which doesn't require any proof of forced fraud or coercion, which is very difficult to prove. Trafficking prosecutions, trafficking civil lawsuits are very challenging, and it's hard to prove that those subtle threats and that subtle intimidation could actually keep a worker in forced conditions. Child victims of sex trafficking just have to prove their age and that they were participated in the commercial sex industry, and whoever was overseeing that operation, whoever benefited from that operation, is a trafficker. So that's the reason that for the large proportion in those numbers. But at least in Los Angeles, the LAPD, who was passionate about anti-trafficking issues, passionate about labor trafficking issues, wanted so much in our vast city, Los Angeles, where there are many different industries, many 3D industries. That's what the International Labor Organization calls the dirty, degrading, demeaning work. LAPD was convinced that there was trafficking in restaurants and in what are they called? Nail salons and back rooms of bars or whatever, and hotels, and garment factories, etc. But these cases were so hard to investigate. These are the individuals who have no opportunity, domestic workers, who have no opportunity, no access to the outside world. And unfortunately, at least the ILO in general, International Labor Organization in general, has repeatedly use the data that the majority of trafficking victims globally are labor trafficking victims. And okay, so that's kind of the lay of the land now. I want to just as I wrap up my remarks, bring it back to this question of democracy and our politics now. I was sharing with my dinner companions last night that one, I guess, refreshing thing about the Trump presidency so far is that he has not co-opted the issue of trafficking to put himself out there as a proponent of human rights. Every president before him did so. Clinton was the president who signed the Trafficking Act into law. Bush followed him, and that he made explicitly his human rights issue. And as a young lawyer, right out of the gates, right after graduation, I was working on these issues in 2002, and Bush's first human rights initiative was convening the first national anti-trafficking conference, and most were government officials, law enforcement professionals. I think I was one of 3 non-governmental representatives there, and was pushed into some photos with John Ashcroft, and this is in the aftermath of the Patriot Act, and it's kind of exciting for me, but I was also kind of wide-eyed, and I looked like a deer in the headlights, and didn't understand the political implications until I'd been practicing for a while, and the political implications hit home. And one of the biggest case that I worked on before I made the move into academia was a case called Operation Gilded Cage, and it was billed as the largest sex trafficking prosecution in U.S. history. Massage parlors, mostly in the Bay Area of California, but also in L.A. Over a dozen of them were raided by federal law enforcement because those massage parlors were fronts for brothels. They took into custody 130 women. They were unaware of the law at the time. This is a long time ago. There hadn't been the intelligence yet, and intra-training on these issues, or inter-training on these issues. So as a result, there wasn't anywhere for these women to go except for a military base. So unfortunately, they were treated as criminals and not victims, which I know is not the case anymore. And when myself and a couple other colleagues arrived on the scene as the NGO attorneys, already 100 of those women had been determined to not be victims. I don't know how that determination happened, but they had already been sent to immigration detention for removal. There are 30 women remaining to advocate on their behalf that, again, about the subtleties of how trafficking occurs, and that these women, if repatriated to their countries of origin, might experience severe retaliation. Those women, thankfully, remained, but under every administration it changes. Then the Obama administration, there was a significant uptick in labor trafficking investigations and prosecutions, equal labor trafficking, equal sex trafficking investigations. Again, under the Bush administration, I think there were 4 labor trafficking prosecutions, while there were dozens of sex trafficking prosecutions. Under the Trump administration, it's just a cluster, blank, blank, or exclamation point. The attention has diverted from trafficking, which is a much more real thing, and individuals are highly more susceptible to trafficking precisely because of increased border enforcement and also the rhetoric. That pushes individuals desperate for survival, needing to leave their countries of origin, into very unsafe methods of migration. And those unsafe methods means unscrupulous smugglers and traffickers. Our immigration clinic at Loyola, we always carry several trafficking cases a year that our students are the primary attorney representatives for. And I think right now on our docket, all of our clients that were trafficked are Central American refugees, unaccompanied minors. And they were fortunately, it was a catch-22, because fortunately they weren't kept in immigration detention because they maybe had a distant relative or a guardian that agreed to take them in, but then they were trafficked. They're literally put into forced labor conditions. And so without doubt, increasing immigration enforcement leads to an increase in trafficking. I'm going to end by noting another sad fact, which reflects again on the relationship between immigration and trafficking. Perhaps many of you have heard that immigration detention facilities, there are a number of them throughout the country, our prison facilities, immigration detention facilities, the way it mostly operates now, are contracted to private corporations. Unfortunately, there are several immigration detention facilities across the nation who have been forcing their detainees to work. That's a violation of the 13th Amendment. Immigration detainees are not criminals. Immigration detention is not criminal punishment. It's meant to detain non-citizens who are in removal proceedings, who either have nowhere else to go or the court determines that they're a flight risk. Maybe because they have nowhere else to go, they have no stable place to go. And these detainees, law-abiding, asylum seekers, having suffered torture in their countries of origin, are now being forced to work by these immigration detention facilities. With that, I guess I want to say just something inspiring, that our work means more than ever. I really believe that, even though sometimes I feel, and I know many of you do too, feel overwhelmed by the specifics of what we have to do today, and also in any free space we have in our minds, even a second, the white noise from the chaos of our government is what occupies it, and it stokes fear. You know, I have fear of our future, but again, it gives me a great sense of purpose, and I believe that I believe that of all of you as well. Thank you for this time to share my thoughts.
Sure. Okay. We're now going to take some questions until about 10:35. So if you've got questions, we have a few of our SJSI members here to pass around some microphones. So if you've got questions, raise your hands, and then we're also going to check on the Slido app in case any of you had submitted any there. But anyway, if you have questions, raise your hands, and we'll let Kathleen answer those. Okay. Can you try this one? Have one over here? Oh, yeah. Is it?
You made a comment that, I don't know.
It's up there.
You made a comment that, of course, we don't incarcerate victims anymore.
Mm-hmm.
Yes, we do.
Yeah.
And we are in Utah. We don't have safe spaces for girls and women that have been trafficked, and because they've been addicted while they've been in that forced servitude, we do criminalize them.
Mm-hmm.
And we work with hundreds of sexually exploited women in our jails and prisons.
Mm-hmm.
And just, I believe a year or two ago, the legislature said DCFS would take over trafficked children,
Mm-hmm.
but there was no money
Mm-hmm.
tied to that, and so they end up in our detention facilities and in our JJS and our court systems, and so we are still criminalizing victims in this state.
Mm-hmm.
So I'm wondering where you've seen that there has been money attached and what that looks like.
Yeah. I sound schizophrenic, but I couldn't agree with you more. I wanted to acknowledge the advancements that just to give credit to the law enforcement officials who are knowledgeable about these issues, and that the culture in some sense has changed. But an important point that I'm really glad to hear your comments, because an important point that I did want to include in my remarks, adult sex trafficking victims are absolutely criminalized. And that's not to say children aren't also criminalized. Girls that are trafficked, and this has to do an intersection of the work that they are coerced into doing, but also their demographics, because the large majority of individuals who are trafficked in the sex industry are Black and brown women and girls, and so LAPD. So even where I was talking about, like, so LAPD, I was saying, truly, they wanted to, they were sensitive to issues having to do with labor trafficking. But when I would talk to the Vice Unit, who is in charge of sex trafficking investigations, their only numbers were girls under the age of 18. They viewed adult sex trafficking victims as prostitutes that should be criminalized. So they did not have a decriminalization approach to adults involved in the commercial sex industry, nor did they take the time and understand the nuance between adults that worked in the sex industry who were defrauded, forced, or coerced into that versus ones that might be really privileged and freely decided to do that. So I couldn't agree with you more. And I do know, regionally, those that kind of culture of criminalizing victims is more persistent. Since I served on the police commission, I do know the strides that they made, and also the AUSAs that I'd worked with in California had made strides. But that other case I referenced, Operation Gilded Cage, I mean, the press release was the largest sex trafficking case, in U.S. history. But the reality was that these women ended up in shackles, and many of them deported. So I couldn't agree more. But again, I want to give credit to those law enforcement officials that are trying to have a smart understanding of issues.
We've had a suggestion that if you have a question, would you identify yourself and who you are and which organization you're from?
Yeah. Shannon Cox. I'm the executive director of Journey of Hope, and we work with women coming off and girls coming off the street, homeless, trafficked, out of jails and prisons.
I could talk to you for a long time because I'd like to.
All right, Kathleen, we're going to take one from the Slido. Okay, I'm going to choose. I went with a different question. Could you comment on the effectiveness of FOSTA SESTA? Am I saying that right? And the criticism that it is making both consensual sex workers and sex trafficking victims less safe. And maybe you could tell us what that is.
Sure, yeah. And I'd love to hear Shannon's views also. So I don't know what the acronym stands for. This one's really long. But it is federal legislation that would set restrictions on internet servers, providers that are forums for soliciting and patronizing escort services, commercial sex services. And it also requires that these organizations and also NGOs, and there have been similar, there's been similar legislation in the past, to affirmatively assert that they do not promote or support prostitution in order to pass legal muster under these government provisions that are provided under this new pending legislation. And so this legislation is an example of persistent polemic ideological debates within the anti-trafficking community for a long time, since way before the Trafficking Act was enacted. And just briefly, that ideological split was between morally Christian evangelicals who were anti-trafficking primarily because they viewed prostitution as a form of slavery, that prostitution is a type of exploitation so abhorrent that it needs to be abolished. There's no such thing as a woman who would freely participate in that kind of transaction. So there's that ideology aligned with a sort of scholarly community that had an activist element. This is a term of art. They were called radical feminists. I like to call them conservative feminists because this is the camp of Catherine McKinnon and Andrea Dworkin, who wrote really influential stuff on gender and the dynamics of patriarchal society. And Catherine McKinnon, Andrea Dworkin viewed sex itself as a power of domination and subordination, and there is no room for women to seek empowerment, and because of that dialectal dominance from men and subordination by men, and prostitution was an example of that. To those, so those two groups aligned and was a major stakeholder in the development of the Trafficking Act. And then there was the Paul Wellstone camp. And for those of you who don't know Paul Wellstone, he was a really well-known congressman from Minnesota who was a really strong labor rights advocate and human rights advocate. And he proposed legislation that would define human trafficking very much like the UN Trafficking Protocol, which used a unified definition of trafficking, did not separate out labor versus labor versus sex, but called human trafficking forced labor into any kind of industry, whether it's sex or legal industries, like factories and agricultural fields, et cetera. And then there was a third competing bill that was introduced by the Representatives White House, and it was largely focused on just criminal penalties. So the real debate became between those that wanted a binary definition, and that was the the conservative feminists with the evangelicals, and then the versus the Wellstone group that wanted a holistic approach to trafficking. The reason why this was especially emotional and especially divided is because the Wellstone group, in including the commercial industry, along with the countless other labor industries that one could be trafficked into, to the other camp that viewed that characterization of the commercial sex industry as work. And so sex worker activists who felt passionate about preventing trafficking, but believed they could do so by organizing and decriminalizing prostitution. And so those workers who were freer workers would be better eyes and ears inside the community to identify perpetrators and help to save victims. And but the notion of legitimizing commercial sex industry as work is just not in our law today. So the other camp that proposed the separation of those definitions in the end prevailed. I mean, you could call it a compromise measure, but it also prevailed. And then when states were encouraged to adopt their own anti-trafficking legislation, you can see a division among states that their anti-trafficking laws focus more exclusively on sex trafficking, while other states provide either a unitary definition of human trafficking in general, or will at least try to put resources in labor trafficking investigations, and then also adult sex trafficking investigations, which I mentioned have the same kinds of investigatory complications that labor trafficking does. Sorry, that's a long answer.
Questions that we... Okay. All right, so I think to wrap up, I think we're just going to ask a general question. On these feeds, there's just a general question, Kathleen, about how can we help? How can we affect policy change? Like, what advice can you give to all of us that we can reform this, and what can we do to get involved?
Great. That's an important question, and I think it's important to educate people about who trafficking victims actually are, and that trafficking increases, at least for foreign nationals who are trafficked, because of draconian and restrictionist policies at our borders, and that's fact. And with respect to citizens who are trafficked, it's important to educate them that among those citizens, these are people of color, and they've been marginalized by the power structures that are entrenched in our government, and the continuous victimization of those populations is rooted in our history, and continuous criminalization of those populations are also rooted in our history. And I think there are a lot of myths about who trafficking victims are, and also how complicit our government policies are. And that's not to say, we want a democratic government that makes it possible for all of us to pursue life, liberty, and happiness. That's why we're in these jobs, and that's what all of you can do.
Thank you. A big thank you to Kathleen and for all of you and for your questions. We're going to take a brief 10-minute break, and we'll meet back here at 10:45 for our awesome panel. Thank you.
Oh, sure.
That was wonderful.